Good morning. My name is Malcolm Neaker. Welcome to Fretton's 8th Insolvency Coffee Break briefing of 2024. Last month it was the summer. Whatever happened to that? Anyway, just a couple of parish notices this morning. First of all, the reminder I always give you to remember the retention of title website tool that I showed you last year. It's completely free to use, and why not have a quick play around with it at the end of this presentation if you've not already done so. Second reminder is that I do pre-pack evaluations, and I'll be very happy to give your buyer an estimate if you're looking to be appointed shortly in an administration where you're intending to sell soon after your appointment. There will be a chance to ask questions during this morning's presentation. Please ask them through the question box, and I hope pick them up as we go, or possibly at the end. I'm aiming, as always, to finish the presentation at around 11 o'clock, but I may go on a bit longer to answer questions if there are any. Okay, that is the housekeeping out of the way, so I will now start the presentation. Welcome. Today's Insolvency Coffee Break briefing is on your legal responsibilities if you are appointed over a debtor whose portfolio includes a high-rise block. I'm going to start with a somewhat random photograph. This is Southampton Police Station. You may recognise it. Perhaps not the most architecturally distinguished building you've ever seen, and this photograph comes from the architect's own webpage, where even they have put on a photograph of it at night when you can't see it quite so well. I'll explain later what the relevance of that is. There are 4 topics I'm going to cover today. The first one is looking at the legal background behind the ownership and management of blocks of flats generally. Secondly, I'll be looking at who has responsibility for safety of a block of flats under the relatively new legislation, the Building Safety Act. Then I'll be looking at the effect of the insolvency of a responsible person and the notices that you will have to give to others in that situation. And I'll finish by looking at the other duties that you might pick up if you're appointed over a debtor who is a responsible person. So first one of those, let's look at the ownership and management of blocks of flats under English law. And the trick here is to arrange an ownership structure in such a way that people can buy and own their own apartments in the block and can sell them on when they want to move out. And also to make sure that things like the lift get fixed when they go wrong. And typically, the way that English law deals with this, English law is not very good at coming up with a solution to this important issue. And the reason why it's not very good is because privity of contract means that contractual obligations are only binding between the parties to the contract. So if you have a block of flats which is sold as a series of freehold apartments, and you buy an apartment on the 5th floor, then you won't have a contract with all of your neighbours in the block, which means it's very, very difficult to make sure that they pay their fair share towards the insurance of the building and to fix the leaking roof when it happens. So privity of contract means it's very difficult to have freehold flats. The answer under English law is to use privity of estate and to set up a relationship of landlord and tenant, which is then going to be a legally enforceable relationship, and the covenants of the leaseholder can then be enforced by the freeholder. And you then have one freeholder for the block as a whole. And the solution there is a lease has to be for a fixed duration. It is limited in time. So typically leases of flats will be for something like 125 years. There'll be long leases. And the flat owners, the leaseholders, will buy the interior of the apartment, but the developer, the freeholder, will continue to own the grounds and the structure of the building itself. Because all of the flat owners are tenants, leaseholders, they have to keep to the terms of the leases that they've got. And those leases will all be in very, very similar terms. And essentially, the general purpose of it will be that the landlord will be responsible for managing the block, and the leaseholders will all have to pay an agreed proportion of the landlord's costs of maintenance, repairs, and management. The landlord, as freeholder, is also entitled to collect a ground rent from each of the flat owners, each of the leaseholders. And as the leases come towards the end of their term, the landlord then has the ability to sell to the leaseholders extensions to their existing leases or new leases, and there will be a further element of profit from the freeholder in doing that. And many blocks of flats have a slightly more complicated structure than that, where they separate the responsibilities of management and maintenance and put those into a separate management company. And that management company will usually have a long lease that has a similar duration to the leases of each of the flats. And the freeholder then simply has the economic interest of collecting the rent and selling lease extensions when they come due. The management company in a situation like that is usually, in effect, a not-for-profit company, a mutual that is owned and trades with the leaseholders who each own apartments in the block. There is a third alternative to freehold and leasehold ownership, and that is common hold interests, or common hold ownership. You probably won't have ever seen a common hold. They are extremely rare. They have existed for more than 20 years. They were brought in by the last Labour government, but for various reasons, they simply have not taken off in this country. English law is a complete outlier in this regard. Most other developed legal systems have a very well established and very effective system in place that does allow people to buy apartments and own them outright in a way that common hold was supposed to do, but hasn't really taken off in this country. I suspect that now we've got a Labour government again, and that it was a Labour government who brought in the common hold legislation, that this is something that will probably be revisited within the next few years, and I suspect we probably will see a new form of common hold being introduced, and one that perhaps this time is actually going to work. So what we normally find is that blocks of privately owned flats are usually managed by a management company, and that's very often a mutual organisation controlled by the leaseholders themselves, or they will be managed by a landlord who owns the freehold of the building and its grounds. There are also, of course, some blocks of flats that are let on shorter tenancies, typically where the tenant pays a monthly rent, and those tenants do not have the right to sell their lease at all. And those blocks of flats normally tend to be managed by the landlord, that the landlord has legal responsibility for them as the freeholder. I'm not quite sure what's happening here. I keep seeing previous slides flashing up, and I hope this is all working for you anyway. Regardless of who is responsible for managing the block, whether it's the freeholder or the management company, they very often delegate that job to managing agents. The managing agents will act on their behalf, they'll be their subcontractors, but the landlord or the management company, as the case may be, continue to have legal responsibility for management of the block. So that's the background to ownership and management of flats in England and Wales. Let's move on now to the Building Safety Act and what that says about responsibility for the safety of blocks of flats. There are two key definitions I'm going to give you at this stage. The first one is the definition of higher risk buildings. And essentially, a higher risk building is a very tall building in which people live. And along with the definition of higher risk buildings, there's also the definition of an accountable person. And the accountable person is the person who is responsible for safety of a higher risk building. And because it's a statutory duty, statutory responsibility they've got for safety, they cannot pass that duty on to anybody else. The buck stops with them by law and will always stick with them. Broadly speaking, these are the duties of the accountable person. And I won't go through those in detail, but you can see they're more or less probably what you would expect of somebody who's got that sort of responsibility. And the Building Safety Act has also established a building safety regulator who is part of the Health and Safety Executive. And there is also a register of high-risk buildings. And this is an extract from the Register of High-Risk Buildings for one of the large blocks of flats in Southampton. That's a brief overview of some of the main points in the Building Safety Act. I'm now going to move on to talk about what happens when a responsible person becomes insolvent and the duty that you would have as an insolvency practitioner to give notice of that to others. Now, you're on the board, you'll have spotted that I was previously talking about an accountable person, and now I'm talking about a responsible person. So these are two slightly different definitions. Every accountable person is a responsible person, but there are also some landlords and management companies who may be a responsible person even though they're not an accountable person. And if you're dealing with the insolvency of a responsible person, which will include all accountable persons, then you have duties to give notice. So if you need to know whether the debtor is an accountable person or not, you should start by checking the Building Safety Regulators Register. If they're on there as an accountable person, they are an accountable person. But if they're not, that doesn't mean that they're not an accountable person. And there are organisations and individuals who are responsible persons who are not accountable persons who do not need to register with the Building Safety Regulator. So showing that as a Venn diagram, all accountable persons are responsible persons, but some responsible persons are not accountable persons. And accountable persons are responsible for the safety of very tall buildings. Responsible persons are responsible for the safety of tall buildings. So here's another distinction coming in, the distinction between a tall building and a very tall building. I'll talk about that in a minute. But one of the other things you're going to need to know is what sort of debtor might be a responsible person. Which circumstances might trigger you to start to think that you could be picking up the responsibility for safety of a tall or a very tall building. And these are a list of examples: freeholders, estate owners, landlords, but not landlords agents, management companies, but not managing agents, and residence management companies, but not necessarily residence associations, also right to manage companies and common hold associations, which are both particular types of statutory management organisations. And the actual, it's essentially the red light should start flashing if your debtor's portfolio includes a tall building that people live in. Now, the actual statutory definition of who is a responsible person is legalistic and technical, but basically that list is a pretty good idea of what you should be looking out for. Now, I've got a flow chart here, and if this has worked properly, you should be able to download it from this presentation. But this flow chart shows you when your duty to give notice might be triggered, who you have to give notice to, and what sort of notice it is. So looking at the first point on the flow chart, if you're about to take appointment and the insolvency might be of a responsible person, which of course includes an accountable person, you may have to give notice of your appointment to the council, to the fire brigade, and to the HSE, the building safety regulator. And if you have to do it, you will have to do it within 14 days of your appointment. So very early on in your appointment, you'll have to give notice to comply with the statutory obligation under the Building Safety Act. So first thing you need to do is look to see if it's the sort of appointment that is going to trigger that requirement or not. The list on the left are the sorts of appointment that will trigger the responsibility. Those on the right are not. Those on the right you'll see are the debtor in possession procedures. Those on the left are not, and they include administration, receivership, including fixed charge LPA receiverships, liquidations, and bankruptcy. So all of the common procedures are there. Second thing you need to look at is whether your debtor is responsible for a tall building which contains 2 or more dwellings or other residential units, 2 or more places where people might live. And if so, you will have to give notice within 14 days. And there is, of course, a statutory list of what information you have to give notice. And you'll have to give that notice to, in every case, the council and to the fire brigade. And if it's a very tall building, you will also have to give notice to the building safety regulator. So that's the flow chart that you can download from this presentation. I've also got flow charts for the bottom 3 bits there, which deal with, are you really sure whether it's a tall or a very tall building? And if you need to look at those flow charts, give me a shout and I can pass them on to you. So broadly speaking, if it's a tall building, you need to give notice to 2 people, the council and the fire brigade. If it's a very tall building, you need to give notice to 3 people, and the extra person you give notice to is the building safety regulator at the HSE. So what's the difference between a tall building and a very tall building? Well, there are detailed rules about how you measure the height of the building, and you can either do it by measuring its height in meters, and if it's more than 11 meters tall, sorry, 11 meters or more, it will be a tall building, or you can do it by counting the stories above ground, with rules about what to do if there's a mezzanine floor. And if it's got 5 stories or more, or if it's 11 meters more or more in height, it will be a tall building. And if it's got 7 stories or more, or if it's 11 meters tall, it will be a very tall building. And if it's a tall building, or indeed a very tall building, it may be a relevant building. So if it's 11 meters, 5 floors, it could be a relevant building. But the only buildings that are going to be higher risk buildings, where you actually need an accountable person registered with the health and safety executive, is a very tall building which is 18 meters or 7 floors in height. So again, showing this as a Venn diagram, you have tall buildings, and some tall buildings are very tall buildings. Some very tall buildings are higher risk buildings. And if it is a higher risk building, then the debtor might be the accountable person for that building. And if they are the accountable person for that building, they will be the responsible person for that building and you will have to give notice if you are appointed over them. Some tall buildings, even if they're tall enough to be a very tall building, can be relevant buildings. And if they are a relevant building, then the debtor might be the responsible person for that building, in which case you would have to give notice to the council and the fire brigade, but not to the building regulator. So that summarizes the difference between a tall building and a very tall building, and the difference between a relevant building and a higher risk building. Trying to put all of that into the form of a table. If it's an ordinary building, which is one that's got fewer than 5 stories and is below 11 meters in height, you don't have to give notice to anybody. If it's a tall building, it may be a relevant building, in which case you have to give notice to the council and the fire brigade. If it's a very tall building, 18 meters, 7 stories high, it may be a higher risk building, in which case you have to give notice to the council, the fire brigade, and the building regulator, and there will be an accountable person for it if it is a higher risk building. That accountable person may not be identified, nobody may know who they are, and they may not be registered, but your debtor might still be that accountable person. Then there's also the type of building it is, because this is not just about the height of building alone. So, for example, if it's a hotel, a care home, or a hospital, then even if it is tall enough to be a higher risk building, it won't be a higher risk building, because there is a different, separate safety regime in place for buildings of that sort. I'm not going to talk about it today. If it's tall enough to be a relevant building or a higher risk building, it will only be a relevant building or a higher risk building if there is either a dwelling there or a residential unit. Neither of those are defined. We're back to this picture of Southampton Police Station. Let me explain the relevance to it. I found these architectural drawings which show what it's like inside. And if we count the floors, you'll see that there's a mezzanine floor, and whether that counts as 1 or 2 floors, and I haven't needed to work out whether it does or not. There's still either 7 or 8 floors, which means that it is tall enough to make it a higher risk building. Now, you might think a police station is not going to be a higher risk building because people don't live in police stations. It's basically an office. And what's relevant if it's tall enough to be a higher risk building is whether there are residential units in there. And all dwellings are residential units, but the definition of a residential unit is broader than the definition of a dwelling. And a residential unit probably includes the police cells, and there are 36 of those in the police station. And this diagram shows whereabouts in the building they are. So the question of whether this is a higher risk building or not will boil down to the question of whether the NIC is treated as a separate building to the office part of it. And if it's one building, then it would be a higher risk building because the 36 cells are 36 residential units, and that therefore potentially brings this into the definition of a higher risk building. So if you're looking at a liquidation or administration of a property company which owns the freehold of various commercial buildings, you do need to look at those commercial buildings to make sure that none of them fall into the category of a higher risk building or a relevant building for the purposes of the Building Safety Act. Because if they do, then your appointment is likely to trigger the need for you to give notice and possibly other obligations as well. The question of whether Southampton Police Station is one building or 2 is difficult and complicated. I mean, there is an answer, but I'm not going to go into that right now. So again, remember, if it's a relevant building, there are 2 people you have to give notice to. If it's a higher risk building, there are 3 people that you have to give notice to. And potentially some buildings that you might think of as commercial or mixed use buildings could fall into those categories. That's a list of what you need to put in your notice if you are having to give notice. I'm not going to go into that in any detail. The important thing is that you need to give this notice within 14 days, which means you're going to need to know very early on after you've been appointed whether you have actually picked up any buildings for which you are dealing with the insolvency of the responsible person. So you're going to need to find out right at the outset, probably before you even take appointment. So let's look at what other obligations you might pick up if the debtor you're dealing with is a responsible person. If you have to give notice, that is a personal duty on you as the office holder. It doesn't seem to be a criminal offence if you don't do so, but I'm sure that your RPB will be monitoring compliance with that along with everything else. And there is clearly a significant reputational risk if you fail to do so when you should have done so. As a responsible person, your debtor will have obligations to the leaseholders under the covenants in the leases. As a responsible person for a tall building, they will also have some statutory duties. And if it's a very tall person, sorry, if it's a very tall building, they will be the accountable person and they will have additional statutory duties. Now, those are all duties on the debtor rather than on you personally. But watch out in a bankruptcy, because when the property vests in you on your appointment, if the debtor is the sole owner of the property, then you could be potentially the responsible person, the accountable person, in substitution for the bankrupt. I don't know whether it would be regarded as that way or whether you would actually have to have the title registered in your name before you become the responsible person or the accountable person. But there must be at least a risk that as trustee in bankruptcy, you could become the responsible or accountable person immediately upon appointment. The duties in a corporate insolvency that the debtor will have are ones that you don't have personal liability for, but they can be enforced by criminal sanctions, and you could yourself be caught up in that, and you could perhaps be prosecuted as an officer. Now, the legal authorities on whether an administrator or liquidator is an officer of the company, if there is a criminal prosecution, have tended to come down in favour of the insolvency practitioner so far, but it's still not a clear-cut issue, and so there is still most definitely a risk there. And even without personal liability for those duties, you may find that other parties, leaseholders, regulators, statutory authorities, still want to enforce those duties, still very anxious to ensure that they are complied with. And you might find that compliance is difficult and expensive, yet remains important, despite the perhaps lack of funding in the case that you have taken on. And even though you may not have personal liability for non-compliance, there are still going to be significant reputational and regulatory risks. So I think a lot of insolvency practitioners will want to think long and hard before taking on an appointment of this sort. I think I've got a question. Yeah, the question here from David Bridges is what is the advice if appointed over a debtor whose solvent subsidiary or parent is accountable or responsible? Can we rely on that being a separate legal entity, or is there still some duty to report? Well, yes, you can still rely on that as being a separate legal entity, because the purpose of the legislation is to have clarity about who the responsible person or the accountable person is. So if the responsible person or the accountable person is a related company, but one that you're not responsible for, then you're not responsible for it. But you do still have the risk of reputational risk, I would imagine, if you're dealing with the parent company and there are subsidiaries that are solvent, but which are perhaps not complying with their statutory responsibilities, are in some way defaulting. You'd have to be aware of that, and you'd need to know that you knew about the situation and you were taking sensible decisions about them, I think. So there is still going to be a degree of reputational risk in a case like that. I think you should be adding some questions to your pre-appointment risk assessment. The first one is to find out if the debtor is responsible for the maintenance or safety of any tall buildings. And if they are, you'll then need to assess whether they are relevant or higher risk buildings. You'll probably search the register in any event, but remember that the register is likely to be accurate if it tells you that the debtor is the accountable person. But if the register is silent, that doesn't mean that your debtor is not the accountable person. And if you are going to take appointment over a relevant or higher risk building, you'll need to carry out some further pre-appointment work in terms of what funding you have available and you might need, what the various obligations are, and perhaps what the state of repair and the issues around the building are. It's not always going to be clear whether you are appointed over the responsible person or the accountable person for a building. If it's a tall building and you might be the responsible person, you might want to give notice as a precaution, just to avoid the risk of failing to give notice when you should. If you might be taking appointment over the accountable person for a very tall building and you decide to give a precautionary notice, then that of itself might trigger the requirement for you then to register the debtor as the accountable person. And there could be significant expense involved with having to undertake that registration in terms of the information you would have to supply to the regulator to do that. But of course, if you have to give notice, then you have to give notice. You don't have the option of deciding not to do so. And I think one of the things that you would almost always want to do in the case where you are taking on the insolvency of a responsible person is to make sure that there are competent agents appointed to do the work of managing building. And I don't think you should assume that the agents already doing the job are necessarily going to be competent or the right people to continue with. Right, we're on to the final straight now. I've got a 5-slide summary that just goes through some of the points that I've already covered. So this slide lists the appointments that will trigger the requirement to give notice, and then those that will not. Those that don't are the debtor in possession procedures. These are the sorts of business that you need to watch out for, because these are the sorts of businesses that might be a responsible person if the property portfolio includes a tall building in which people live. This is the slide that shows the difference between tall buildings and very tall buildings. The legislation starts to kick in when you're looking at buildings which are 11 meters or 5 stories high. Those are what I'm calling tall buildings. Some of those tall buildings will be relevant buildings, and if they are relevant buildings, there will be a responsible person, and that might be the debtor that you're dealing with. Some of the tall buildings are going to be very tall buildings. They will be a very tall building if they are 11 meters high or have 7 or more floors. Some of those very tall buildings will be higher risk buildings. And if it's a higher risk building, there will be an accountable person who might be your debtor, and the accountable person will always be a responsible person, so will trigger your obligations if you are appointed over them. If it's a hotel, care home or a hospital, and it's a very tall building, it won't be a higher risk building, but there are separate regimes in place for those. And if there are more than 2 places within the building where people might live, using that term very, very widely, if it's a dwelling or a residential unit, that can be enough to bring a commercial building into the definition of a relevant building or a higher risk building. And if it's an ordinary building, one that's lower than 5 floors, 11 meters, you don't have to give notice to anybody. If it's a relevant building, which will be at least 5 floors or 11 meters high, you will have to give notice to the fire brigade and the council. If it's a higher risk building, which are some buildings which are more than 11 meters, 7 or more stories high, you will also have to give notice to the building regulator, and there will be an accountable person registered for that building with the building regulator. Right, I'm asking for more questions. I see that there's another question that's come up here. Question is, will disclaiming the property also absolve the office holder from being responsible or accountable? Well, I think probably it would, but I think there would be tremendous reputational risk in disclaiming in a situation like that. Just because this is a safety issue, and for you to be appointed over a company which has got safety obligations, where in fact one of its main functions is to be a safety organization, and then to disclaim your interest in it is probably not the sort of thing that insolvency practitioners should do in the interests of the reputation of the profession. And there's my colleague here, Nikki Atkins, is a specialist in residential leaseholds. And she and I were having a conversation last week, and she was telling me about some of the other aspects of the Building Safety Act. And one of them, without going into the detail, is that management companies have got now a much greater risk of incurring financial obligations, particularly to the leaseholders, than they did before. And of course, these management companies are fundamentally, they're mutual organizations. They're trading with themselves. They're owned and controlled by the leaseholders who own apartments in the block. The only income they have is from the leaseholders in the block. If you impose financial penalties on those organizations, the only place that they can recover those penalties from is the leaseholders in the block. And if they're not able to do that, perhaps because the penalty was only incurred because they were falling short in terms of their obligations, then there's nowhere for those organizations to go other than insolvency. And I'm not sure that insolvency really is terribly well suited with the procedures we've got at the moment for dealing with the insolvency of a self-dealing mutual of that sort. And I just wonder if perhaps there's a need for the profession to get involved in the dialogue around new common holds, if there are going to be new common holds, because those are likely to involve a mutual common hold association to administer common hold apartment blocks. And I think there needs to be some new sort of insolvency procedure for dealing with those sorts of insolvencies, because I don't think the current system is really sophisticated enough to cope with it. Because the normal solutions of either selling the assets won't work, and the normal solution of simply dissolving the organization and striking it off isn't going to work either, because there will be an ongoing need for some sort of organization to continue to manage and be responsible for the safety of the block. But I digress on that point. If there are no further questions, then Just a reminder that I've got these additional detailed flowcharts if you are feeling particularly masochistic and you want to see them. And just some notes for your diary coming up. Next coffee break briefing, unless I change my mind, is likely to be on insurance claims and insolvency, and particularly the third parties' rights against insurers legislation. Later this week, I'm going to be at the CESCA conference at Reading University. I'll be speaking on Thursday morning. And if you haven't booked your place on that, then please do so. I think there's still time to do that. The next item on the diary list is the CESCA DENBIS seminar, which is on the 10th of October. And again, I'm speaking at that. Please do book your place on that if you'd like to come to that. The November coffee break briefing, I think, will probably be on insolvent partnerships, and there's also the R3 SPG forum early in November. I'm hoping to go to that this year, but I'm not sure I will be able to, but it's usually a good event. And then looking ahead to next year, we've got the R3 Southern and Thames Valley Forum is going to be hosted in Bournemouth in March 2025. And we'll have the Fretton's 4th annual insolvency conference, to date yet to be set, in June next year. And so with that, if there are no more questions, I'll just say thank you very much for your attendance. Maybe see you later this week. If not, then look forward to seeing you at the next coffee break briefing next month. Thank you and goodbye.